Both Matt and Anthony are partners at our firm, and they have robust practices that include employment law. I'm sure that many of you who are on the session with us today have worked with them. Matt focuses on human resource, free expression, constitutional, and administrative law, and he's appeared at all levels of court here in Alberta and before the Supreme Court of Canada. Anthony focuses primarily in his practice on all matters related to work in the workplace. He advises both employers and employees in both the private and the public sectors. So with that, I will turn it over to Anthony, and I will disappear and you'll see me at the end.
Thanks, Christine. And so, as Christine mentioned, we're kind of 2 weeks from our first session. And that first session, it was, a matter of navigating the chaos that was coming, and it felt like we were dealing with new changes to the law, every day. It appears as though that's starting to level out into it's just brand new changes every 2 to 3 days. But in all seriousness, what we've tried to put together for you today, now that there's been at least a little bit of settling and at least a little bit of understanding of what the path forward looks like, is I'm going to spend a portion of time talking about the various programs that are in place, because there's a great deal of information out there, and there's a lot of either confusion, misinformation, or things going under different names, or programs that get announced and are then no longer called that anymore. And so I'm going to go through and try and kind of provide you some guidance as to what these programs are. And then Matt's going to go into the specific options that employers and employees have, and he'll also be tying them back to how they relate to some of these programs, in a way that will hopefully give you some action items and some ability to move forward as your business, your operation, whatever it may be, is trying to navigate these very unique times. And not the least unique, because I'm presenting with a light pink and a light blue chair in the background, which is a little different for me. My house this room doubles as a grade 1 classroom for a little while every day. In any event, so what I'm going to go through now is we've broken up the different government programs into kind of 3 categories: ones that are more focused at employers, ones that are more directed towards employees, and then a few of the newly announced ones that are getting a lot of press. And one thing I want to mention before, as I go into this, is as best we could, I've gone through and I've had the assistance of a couple of the associates at the firm to try and dig down to get the actual legislation, as opposed to relying on the sound bites or even the websites, because in some circumstances we've learned that the websites will even get things wrong. So we'll start then with the employer targeted programs. There's a whole whack of them, as you can see here. And the first one is this temporary wage subsidy. Now this is different. This is a separate subsidy than the one that's gotten a lot more press over the last 2 days. And I'll be talking about that one in more detail. That's other one's called the Canada Emergency Wage Subsidy. This temporary wage subsidy was put in place to allow employers to reduce their payroll remittances for up to 3 months. So from March 18 to June 19. And you'll see that March 18 is a key date for mid-March, but March 18 to March 15 is a key date for a number of these. Now this is a federal program, and essentially it's widely applying. It applies to, for the eligibility of it, you have to be either an individual, partnership, any corporation, a nonprofit, a charity, a Canadian-controlled private corporation, I should say, with a taxable capital of $15 million or less. So it's, you know, designated towards mid-size and smaller employers. You have to already have a business number and a payroll number in place, and in which case you'd be eligible for the subsidy. The subsidy is up to 10% of the remuneration you pay for your employees during that March 18 to June 19 time period. You don't actually have to apply. There's no application process for it, but this also won't be calculated by the CRA. They're not going to bend over backwards to do you any favors. So the way this works, and again, this is the temporary wage subsidy, is you do all your deductions as normal. But then when you're doing your payroll remittances, you can, excuse me, that you can reduce the remittance, and you can start doing this in your first pay period that includes pay from, or your first remittance that includes pay from March 18 to June 19. So for those of you, for example, if you're paying, you know, if you've paid monthly at the end of the month of March 31, then this would apply. And so you're able then to reduce the amount you're remitting for taxes, not for CPP or EI. You have to still remit the full amounts for those, but you can reduce those by 10%, and that is kind of how the subsidy is operating. And that 10% amount up to, and I should say the 10% goes up to $1,375 per employee to a maximum of $25,000. So there is a cap, but the 10% is the starting number. And that amount then works, counts as income. It's because it's technically a subsidy from the government, even though the way you're claiming it is by leaving it off your remittances. There's still, this is kind of, because it was rolled out so quickly, they're still clarifying the reporting obligations. So, you know, you'll want to double check the requirements and make sure that you're doing the proper deductions to your remittances, or that your payroll people are doing that and keeping that in mind while doing it. Because as I mentioned earlier, the CRA is not going to be administering this and directly. It's going to be up for the employer itself to do it. And as we'll hear later, that's because the federal government is pretty much getting the CRA very busy on a number of other things. One thing to keep in mind of this as well is when I'm talking about the Canada Emergency Wage Subsidy, that's the other wage subsidy, is there's a reference there that you essentially won't be able to double dip. And what that means is that if you've claimed for and taken advantage of this subsidy program, that you won't be able to do the full, get the full 75% subsidy under the Canada Emergency one, although the actual mechanics of how that's going to work hasn't been made clear yet. The other measure, we talked about this briefly in our first session, was the work sharing program. This program is set up for employers that can show that they're suffering from a 10% temporary reduction in business. Public sector employers are not eligible. Now, in terms of public sector, it appears as though that's referring to crown corporations and municipalities, universities, etc. It's not clear, and my argument would be it wouldn't apply, or sorry, what I should mean is that a corporation set up and owned by, or run by a municipality, it's a separate legal entity. I think there's a reasonable argument on the wording of the legislation that they could participate in a work sharing program, but you may need to look more closely at how that corporation is actually set up. Otherwise, if it does apply to nonprofit organizations or any other private company that shows a reduction of 10%, the 10% reduction has to be shown to be temporary and beyond the employer's control and not cyclical. You also have to provide a recovery plan The big thing with this work sharing program, what it is that you're allowed to, you can keep your employees continuing to work, and then their pay gets topped up. So you have them working at a lower amount, but their pay gets topped up by Service Canada. So it's a three-party agreement then between Service Canada, the employee or group of employees, and the employer. And so because there's three parties involved, there's an application process, and it can't start until 30 days after the application is filed. And that hasn't changed under this new plan. So it's something worth considering. If you're, if you're being as if you look at some of the more pessimistic projections as to how long the slowdown is going to be continuing for, but you need to keep operating and you want to keep your employees working. So if you get this application in, it can kick in 30 days from now, and it can continue. And this is where the change is the government changed it. It originally was only able to go for 38 weeks. It's now can go as much as 76 weeks, subject to renewals. So this may be something that employers can do in order to kind of keep workers working and keep operations going. You have to maintain all your benefits, and you still will have to cover the full cost of any statutory holidays. The government will not cover those. So keep that in mind, that this isn't that this won't be a straight reduction of pay across the board from your financial line, that there may be some issues that you're going to have to costs that you're going to have to continue. One of the other changes that the government has put in as a result of COVID-19 with respect to these plans is that they're requiring less for the recovery plan portion, because when you apply, you're supposed to provide a recovery plan that says this is temporary, this is how we're going to get out of it, this is when we expect the recovery to happen. The government's acknowledged that may be very difficult for organizations to do right now. Now, with respect to item C, federal business income tax deferrals, is essentially all filing dates have been moved back to June 1st, 2020, and businesses may defer until August 31st, 2020, the payment of any income tax amounts owing on or after March 18. So there's that March 18 number again. So any income tax amounts that are owing on or after March 18 are the payments deferred with no interest or penalties until August 31st, 2020. I'm going to quickly hop to E, because which is the Alberta corporate income tax, because that's the same. So the same change there, which is your income tax is deferred from March 18, 2020, any payments to August 31, 2020. So C and E, it's a movement from March 18 to August 31 with respect to any income tax payments, and the filing dates have also been moved back. With respect to D, the deferral of sales tax remittances, essentially, if you have to do any remittances for GST, or you have to make any customs duty payments, then you can now defer those until June 30th, 2020. And that is for if you're a monthly filer, and for your February, March, and April 2020 reporting periods. If you're a quarterly filer, then anything in the first quarter, so up to March 31st. And if you're an annual filer whose installment is due in March, April, or May, then again, for all of those categories, it's all been deferred for those payments and remittances to June 30th, 2020. The property tax deferrals, the collection of property tax is going to be deferred for 6 months. Frankly, the details on this is provincial. The details on this are still scarce. One of the things that the provincial government has said for municipalities is that they have to set their rates as normal, but defer the collection of half for the 6-month period. And you'll see this a lot in the various things that the government has noted on their various programs. But one of the things that kind of jumped out at me on this one was to say that if you can pay your taxes, you are strongly encouraged to do so. So don't use this as an excuse to not pay. And with respect to some of, for example, the wage subsidy, the government has been quite clear that they're planning on implementing pretty significant hammers to use against anyone they see abusing these programs. So keep that in mind, that, you know, to make sure that you've kind of done the legwork to determine why you need this and how it's going to benefit your company or organization. WCB premiums, they've deferred premium payments for all private sector employers until 2021. And if you are a small or medium business, then you're only going to have to pay 50% of that premium in 2021. So if you've already paid, then they are either going to reimburse you automatically, or they said in some circumstances they may have to contact directly. So essentially, private sector employers are going to have significant reductions to their WCB premiums for this calendar year. Utility payments, small business consumers can defer their utility payments for a period of 90 days. Again, that's starting as of March 18, so 90 days goes until June 19. You are eligible for these deferrals if you are experiencing financial hardship and cannot make your regular payments as a result of the COVID-19 pandemic. And this would include, they've said that if you are already in arrears as of March 18. So it's not that if you get into arrears after March 18, if you're already in arrears, you can get this deferral for 90 days. It applies for, there's a cap in terms of how much your consumption needs to be to qualify, you know, to be below to qualify for this. So you'll want to check the requirements to see if you fall into that. And this one is set up as one where you're supposed to contact your providers directly, so your natural gas, your electricity provider directly to deal with this deferral. And in terms of the details as to when they'll be granted, as I said, it's not clear. It seems to be the eligibility is just if you have financial hardship and you can tie it to the COVID-19 pandemic. We haven't yet seen the government's trying to cut too fine a hair between differentiating between slowdown as a result of the price of oil and slowdown as a result of the pandemic. Hopefully they won't go there to too much with respect to these programs. And to date, we haven't seen any indication that even federally they're going to be doing so. The last one with respect to these more employer-focused programs is this tourism levy. This is for businesses that provide temporary lodgings and hotels. You can defer making a tourism levy remittance from March 27th until, so anyone that's due between March 27th and August 31, you don't have to worry about it until August 31. You still have to file your returns in the normal course though. So no changes there. Okay, so I'm going to move now to the employee targeted programs that we have in place. Some of these we talked about before, and I won't go into too much detail. The changes to the EI sickness benefit, there was the 1 week waiting period, that's gone. And no medical certificate needs to be provided if you're in quarantine. And also, if for some reason you can't complete your claim because you're in quarantine, they're allowing employees to provide a claim a bit later and get it backdated, which is particularly helpful since the federal government closed all the Service Canada offices, which is going to make it very difficult for a lot of people to make these claims. So that's something that's important to be aware of if you have employees that are, are out of work as a result of quarantine or as a result of them being sick. The supplemental unemployment benefit program, again, this is one where employers can do top-ups to their employees' EI without those top-ups being counted as income that would reduce the EI amount. And that's very important, because we've had some situations where clients want to do the right thing. They say, well, we can't afford to keep open, but we want to pay our employees something during this time to add to their employment benefits, add to their EI. But then what they don't realize is that the amount they're paying them reduces the amount that employee gets to EI. So it's essentially paying them, 50 cents on the dollar. So the way to avoid that is to register one of these supplemental unemployment benefit programs. And it's important if, for those organizations, some will have a plan in place for maternity or parental leaves. Those don't need to be registered with Service Canada. So if you already have a plan in place, you may want to just double check and make sure it's actually been registered with Service Canada. If it's one that you've been using for people on maternity leaves that you now want to use for people who are being temporarily laid off to supplement their income. So you should take a look if you have one of these in place to see if it's been registered with Service Canada. And if you want to use it for any employees that you're laying off, or if you want to put one into place, then in order to assist employees financially who are on EI, then there's a number of specific requirements that have to go into a plan. You can review on the government website, or you can contact Matt or I or anyone else at our office to help put together a plan for submission there. This third one, the emergency isolation support, frankly, is not something that needs to be thought of for too long. This was the provincial government was giving a one-time payment for individuals who had to self-isolate, one-time payment of $1,146. You were only qualify for this if you had been directed to self-isolate, or had been diagnosed with COVID-19, or are the sole caregiver of a dependent who's in self-isolation, and if you have no other income support. And so what that would include EI benefits. And of course, the threshold for getting EI benefits and this new emergency response benefit is quite low, that, frankly, it's very unlikely that this will apply to anyone who's had to self-isolate after March 15th, because that's when the federal benefit starts paying out. And so really this one-time payment would only be available for a few individuals who are missed by that March 15th. So it's still worth knowing that it's there. But as I said, the circumstances in which it's payable is relatively minimal. Finally, and we talked about this at some length at the last time, there's the COVID-19 job protected quarantine leave. It's a 14-day job protected leave if you've had to self-isolate or quarantine. The wording of the legislation of the Order in Council is just 14 days of protected leave. It doesn't seem to indicate that you would get more if you were asked to isolate, for separate circumstances. So, for example, you had symptoms, you were off for 14 days, and then someone else in your family came down with symptoms, and so you had to self-isolate for longer. The wording of the legislation is just 14 days job protected leaves. If someone's going beyond the 14 days, particularly in the current circumstances, it's worth looking into each circumstance on a situation by situation basis to determine whether you can require that employee to come back to work, or whether you can lay them off, or whether you need to kind of keep allowing them to continue their leave. That's going to be on a case-by-case scenario. So moving on now to the three newly announced programs. We just got a whole bunch of information about the emergency wage subsidy yesterday. This is a program for any business, subject to one exception I'll talk about in a second, but any business that has suffered a 30% or larger drop in revenues as a result of COVID-19. This is any size business. The main criteria is the revenue loss. It is not available to publicly funded employers, so municipalities, crown corporations, public universities, colleges, schools, and hospitals, but does include nonprofits and charities. To go back to my comment earlier about with respect to excuse me, go back to the temporary work share program. It appears as though this would probably apply to corporations set up by municipalities or publicly funded employers, but I would urge caution until we see the actual wording of the legislation on the regulations with this, because that has not yet been passed by Parliament or put into place. So it may be available to corporations owned by publicly funded entities, but it's definitely not available to those entities themselves. Now, the subsidy itself will be up to 75% of an employee's salary on the first $58,700 that they earn. So the maximum subsidy is going to be $847 per week, with for a maximum period of 3 months, retroactive to March 15th. In terms of some of the details we got yesterday is how are they going to calculate this 30%? For nonprofits and for nonprofits and charities, they're still going to determine how do you determine whether a nonprofit's lost 30% of its revenue? How do you determine if a charity has done that? They said they're going to work with the various nonprofits and charities to help determine that. With respect to other businesses, for-profit businesses, it's going to be a comparison on a monthly basis of your 2020 revenues, calculated based on normal accounting procedures, your 2020 versus your 2019. So if March 2019 was 30% higher than March 2020, then you're eligible for the subsidy for the period of March 15 to April 11. Then if your April 2020 is 30% lower than your April 2019, then you'll be eligible for this April 12 to May 9th period. And then there's a third period, May 10th to June 6th, which you compare your May 2020 to your May 2019. So it's going to be based on the monthly the monthly revenue amounts. It would exclude extraordinary items and amounts on account of capital. And you'd have to apply essentially each month or each of those monthly periods over the 3 months for the particular wage subsidy. You cannot receive this as an organization if those employees are getting the Canada Emergency Response benefit, because they're getting that benefit because they're out of work. So essentially, if your employees are out of work, you won't necessarily qualify for this as an employer for the subsidy. So far, the latest projection is that this money should be available in the next 3 to 6 weeks. I just checked just before this, and they haven't kind of put together the application materials last I checked with respect to this. The wage subsidy, but I expect that's forthcoming. The Canada Emergency Response Benefit, this is more for your employees. And the application website has been set up for this, effective this morning. I took a quick look through it, went through it. This is going to be administered through the CRA, so not Service Canada, who typically does EI. However, this is essentially starting for anyone really who's lost work since March 15, unless it's for a maternity leave. This is for the interim new EI is the way to think of it. Anyone who's already applied for EI, who's kind of in the process, they're actually going to get funneled into this process. If they're already receiving EI payments, then that's a different story. They'll just continue receiving their EI payments. But if anyone who's applied for EI since March 15th is going to be set up for this one. This, as mentioned, this does not include anyone who's claiming EI for maternity, parental leave, caregiving leave, or work sharing. That's all still going through Service Canada. So those applications still have to go through Service Canada. But starting on April 6th, employees can start applying, or people who are out of work or as a result of COVID-19 can apply to this. And the way they're breaking this up is based on birth date, essentially. And so if your birth date is January, February, or March, you get to apply on Mondays. April, May, June, you apply on Tuesdays. July, August, September, apply Wednesdays. October, November, December, apply Thursdays, or all, and then you can apply Friday, Saturday, Sunday for all of them. So they're trying to limit the application process, but in terms of the amounts that they're getting, this is going to work out to employees, their benefits being $2,000 for blocks of 4 weeks. So it works out to $500 a week. And right now it's going to cover the period from March 15th to October 3. This, in terms of who's eligible for it, it's defined as anyone who has made at least $5,000 in the previous year, including if they've gotten that money through employment, self-employment, or pregnancy or parental benefits, and who have who reside in Canada and have a valid social insurance number. So that would include temporary foreign workers and international students, and who have stopped working as a result of COVID-19, or are eligible for EI regular and sickness benefits. So this is essentially being a funnel for all of EI's regular benefits and all of EI's sickness benefits for this 16-week period. And then at the end of that, it's not going to impact those people's EI eligibility. So for those of you who might be dealing with employees who have questions about this, you know, it's not going to impact their ability to get EI after the 16-week period is done, in terms of it's not going to take time away from that. And the benefits are supposed to start 10 days after they apply. I have a little bit of skepticism about the federal government's ability to roll out programs after the Phoenix fiasco, but hopefully they'll do better this time around. And so that is where you're going to be advising your employees if you have to put them under temporary layoff. That's what you're going to be advising them to apply to, is the CERB, and not go through the EI process unless they're going on leave for pregnancy or parental leave, or one of those ones. Last thing I'm going to talk about is this business credit availability program. Federal government has earmarked $65 billion that's going to go to a variety of lending programs. The best thing to do and deal with respect to these programs, because the way the federal government's dealt with it is to say, talk to your financial institution, and they will be able to advise you whether you qualify and on what basis you're going to get these. It's focused, at least on some of them, towards small businesses, and it'll be on a kind of a piece-by-piece scenario. One thing that's not on the slide, I just wanted to mention as well, because it was just announced, is because this may be of interest to any municipalities or charities or nonprofits, is that the provincial government has just announced additional funding for family and community support services with respect to programs and services that are going towards assisting seniors who have isolated and they need to have their needs met, or anyone else who's been impacted by COVID-19. So there is extra funding out there for those programs, and it's worth kind of looking into as to whether you'd be able to qualify for that, those amounts. So those are hopefully a good summary of all the programs that are available for use for your employees and for you as organizations as you're navigating this. And now I'm going to turn it over to Matt, who's going to talk about kind of some of the specific actions that employers have been taking, can take, and some of the nuances that we've been seeing arising on that.
Great, thanks, Anthony. It's also important just to keep in mind when we're talking about all of the benefits programs that are available, that the information that we're providing today is sort of current as of today. And as we've seen over the past couple of weeks, things tend to change very quickly in this situation. So if you are looking for information in a week or two about those benefits programs, don't replay Anthony's presentation. I'm sure you'll be tempted to do that. But make sure you're going to the government websites to see if there's been any changes or any more details that have been released. Because while the broad strokes of some of these programs are relatively clear now, there will be some additional clarifications that will be coming that will be important from an eligibility perspective for employers. So make sure that you're looking into those issues as well. What I'm going to talk about is really the ways in which employers have been dealing with this over the past few weeks. If you participated in our first webinar, that really was sort of putting on the table a number of different approaches that may be available to employers in these strange times. What we've seen over the past couple of weeks since our first webinar, as Anthony's indicated, is that there has been some degree, at least, of stabilization with respect to the approach that some employers are taking. But there's a few differences and other factors that have arisen over the past couple of weeks that I want to go through. My intention is not to redo the work that we did last time with respect to a lot of the details about the options, but rather to talk about some of the practical implications moving forward. I think what we're seeing most of all is employers are really trying to find the right approach to deal with managing their workplaces. And all of that really depends on a number of factors that we simply don't know yet. The most important one is with respect to timing. So a lot of the options that are available to employers to deal with these circumstances deal with timing issues. So if you're dealing with temporary layoffs or leave provisions, for example, those are going to be for established periods of time. And what we're realizing now, and as more information comes out from government sources about what governments are expecting the timeline is going to be for self-isolation periods and similar issues, is that we're looking at months, not weeks. And before we get back to anything that looks normal, we could be well into the summer, and in some cases, I've heard people estimate sort of early fall. But because those timing issues are so important, it's changing the way in which employers are approaching the management of their employees. So turning to the first issue that we talked about last time that certainly is still on the table for many employers are the temporary layoff provisions in the Employment Standards Code. And of course, those provisions always come with some degree of risk that an employee might claim that employers attempt to use it is essentially a constructive dismissal, because most employment agreements that exist don't actually have a specific provision allowing employers to institute temporary layoffs. Collective agreements, of course, are a different issue, and often those will have layoff and recall provisions. But in a normal individual employment relationship, you're going to be relying on an ability to exercise a temporary layoff that may be subject to challenge down the road. As I indicated last time, my view is that employers are going to have some more practical room to actually put those in place, because this is a circumstance that really no one could see coming. And you may have some greater sympathy in terms of utilizing that temporary layoff provision. As you probably know by now, the standard temporary layoff provision under the Employment Standards Code is for 60 days. And if an employee is not recalled in that 60-day period, their employment is deemed to have terminated. And what that means is you then have the obligation to provide both termination pay under the Employment Standards Code and also common law severance pay, which of course is the much bigger financial component to a potential termination. And so when people were entering into layoffs and indicating that they were putting someone on the sidelines for 60 days, I think they had a realistic expectation that things were going to turn around and that they would be able to recall them in that period of time. We're now realizing that that may simply be impractical. And so there'll be a lot of employees who are on temporary layoffs who will continue to be until the 60th day. And then the obligation to provide termination pay or severance pay is going to arise because businesses simply will not be able to bring those people back. The Employment Standards Code does have some flexibility built into it. It is possible to enter into an agreement with an employee for a longer period of temporary layoff, but that's subject to two things. First of all, the employee has to agree to that longer period, and the employer has to make payment of wages or an amount in lieu of wages, or continue the employee's participation in pension or similar benefits program. So essentially, you can agree with an employee to a period, for example, of 90 or 120 days, but you have to actually give the employee some remuneration or some access to benefits during that period of time. In the last, I would say 3 or 4 days, I'm not sure, Anthony, if your experience has been the same, I've been seeing a lot more employees coming and saying, we want to look at those longer periods of time because we just know that even if things were to start turn around from a public health perspective, we know that our business is not going to be able to ramp up within that next period, for 60 days. So other things to keep in mind, just a refresher, notice is generally required to start those layoffs. That's different from the provisions that existed prior to 2017. So either 1 or 2 weeks worth of notice for the commencement of the layoff. There's an exception for unforeseeable circumstances. There's uncertainty about whether or not the economic consequences of COVID-19 will be directly found to be an unforeseeable circumstance. But certainly many employers are taking that risk and saying, look, there's nothing else that we can do. We have to start these temporary layoffs right away. So just be wary of that. There is some risk involved, but employers are sometimes forced to take those risks from a cash flow perspective. The other thing you want to keep in mind is if you are looking at potentially maintaining an employee on benefits during a leave period that is longer than 60 days, that is to gain the advantage of being able to have a temporary layoff for that period of time, you really do need to check with your benefits provider first in order to ensure that, that you are able to continue benefits for that period of time. So health and dental benefits may not be a problem. Your provider may say, look, as long as you're paying the premiums, then it's completely fine from our perspective. But if there are short and long-term disability benefits, you need to have an understanding of whether or not it is possible to continue those before you make a promise to an employee about that. If for some reason it's not possible to do that, one of the options that employers may have is to determine what the dollar value is for the employer's contribution to those benefits plans on a monthly basis, and then offer, instead of maintaining the actual plan, to give the employee a sum of money that would compensate them for those plans. That's not the best option because many employees, remember, they have to agree to this. So many employees are more likely to agree to that if you're going to maintain them on your benefits plan during that period of time, as opposed to just giving them a sum of money and saying you can go out and seek your own benefits. They're not going to be able to find a reasonably comparable plan, especially if you're a public body with generous benefits plans. In terms of using temporary layoffs, they are likely to be appropriate where the reason for the slowdown in work is related to COVID-19, so that the downturn is directly associated with that, and there's an expectation that once that public health emergency is lifted, there will be a bigger uptake in your business and in your revenues. If you anticipate that the work level is going to increase, that you'll actually be able to call those people back. It also is useful if you are looking to simply delay the expense of a termination. So if from a cash flow perspective, you simply can't pay out termination pay and the potential for severance pay at this stage, a layoff can push that obligation down the road, although keep in mind it does not eliminate it unless the employee fails to return to work when you recall them on 7 days notice. And just remember that when you are instituting temporary layoffs, it's very important that you put some kind of reminder in your calendar about when those dates are coming, so that you will be able to make decisions about what you're going to do with those employees in advance of the 60th day. Because if that 60th day passes, their employment is deemed to terminate and the obligation arises. With respect to other options for employers, of course, there are straightforward terminations, that is terminations without just cause. I've seen more employers over the past few days saying, look, we know that even 120 days is not going to be sufficient for our business to be able to bring people back. And we would rather deal with the issue with respect to termination at this stage rather than delay that through an imposition of a temporary layoff provision. So this option may be appropriate where there are other factors that are impacting the lack of work. So for example, if the business was struggling prior to COVID-19, of course, a lot of private sector industries connected to oil and gas would be in that category, where even once the public health emergency comes or is lifted, it may be that you simply will not be able to call employees back to work, and it may make more sense for you to reduce the size of your workforce by severing that employment relationship right away. This is probably more attractive for employers who have a contractual provision with their employees that limits the entitlement to notice or pay in lieu of notice to the minimum period under the Employment Standards Code, because remember, those max out at 8 weeks. So if you have a provision which does that, it may be more attractive for you to simply proceed with the termination than it is for an employer who does not have such a provision and where they may be looking at having to pay out a substantial common law notice period to an employee. Remember, the notice periods under common law tend to max out at 2 years worth of notice, which of course is a significant amount of a liability on your books, especially if you have very long service employees who are in their late 50s, early 60s. So to the extent that you have valid and binding contractual provisions that limit notice, that may indicate that a termination is the way to go. Or if you have very junior employees, so if you have individuals who potentially started within the past year, your obligation to pay out common law notice is likely going to be much more limited than it would be for a long service employee. Although it's very important to keep in mind that when we're talking about the common law notice obligations, the idea behind it is to estimate how long it's going to take the individual employee to find reasonably comparable work standing at the date of termination. And when we're in the middle of a pandemic, when there are hundreds of thousands of people who have been laid off or terminated looking for work, this may be a factor that courts will look at and saying the notice period is going to be longer than it otherwise would have been. We don't have a lot of law that we can really look to in these circumstances because this is truly a unique situation that we are living through. So those are some factors to take into consideration with respect to terminations. It's also worth mentioning that terminations are, or pay in lieu of notice is not required in the event that the contract of employment has become frustrated. And the way that the Employment Standards Code talks about that is if there's an event that beyond the control of the parties renders the employment relationship unworkable. That's a risky approach to take because of course courts don't like to find that an employee is not entitled to pay in lieu of notice at all, but it is something that can be considered if the circumstances are appropriate. And of course, it's not going to surprise you that I recommend that you seek legal advice before taking that approach, whether it's from us or somebody else, but just make sure that you know what the limits of that very narrow doctrine of frustration are if you decide to rely on it. And then of course, we have to still be mindful with respect to human rights considerations. So if you're terminating or laying off because of a lack of work, that is not going to be a human rights issue. But if there are other factors, particularly if an employee is able to point to the fact that they had been quarantined, for example, or in extreme cases, if they have family obligations that may limit the nature of the work that they can do, there are some human rights risks with respect to family status and of course disability that need to be thought through. So that's layoff and termination. Those are the ones that we focus on in our last webinar because those are the ones that employees were looking to immediately. The other option that I've been seeing more of as well is a reduction in hours or changes to employee schedules. Reducing employees' hours, and of course, therefore reducing the pay that you're giving them is always possible. There are risks that come along with that as well. To the extent that you're able to give notice of that change, of course, that's an ideal approach. It is important to keep in mind, for example, that if you have full-time employees who are on a salary, reducing their hours, for example, to 90% or to 80% with a corresponding reduction in their compensation brings with it risks of a constructive dismissal complaint. And so if individuals have their hours reduced unilaterally, that is, they're not agreeing to it, then if the reduction is considered to be material or fundamental, then there is a risk that individuals can bring a complaint in the courts with respect to constructive dismissal, or in fact simply sue while maintaining their employment for damages as a result of the breach of the employment agreement. That's the sort of legalistic approach, and it's important that you be aware of those risks. But what I can tell you from experience dealing with employers over the past couple of weeks, many employers are instituting hours reductions or simply wage reductions. So if you're reducing wages, for example, by 5 or 10% without a reduction in hours, employers are considering those as well. In my experience, it is something that can be done successfully if it is being done across the board. So if employees know that this is applying to all employees, that is sometimes something that will reduce the practical risk of them actually bringing a complaint. And no matter what you do, make sure that any change that you're making is reflected in writing, because of course you may have to refer back to how it was done, how it was communicated to the employee as well. So just looking at those options and comparing them to what Anthony talked about before, layoffs, of course, give employees access to certain programs that they would not otherwise have. And we talked about the CERB, employment insurance. Those same programs would apply in the event of a termination of employment. Anthony's already talked about the supplemental unemployment benefit program. If you have a workplace where you're wanting to put that in place, it's something to obviously think about in advance. The wage subsidy for employers that Anthony talked about, one of the problems that we're seeing in terms of actually implementing that from an employer perspective is, I've spoken, I think, to 2 employers over the past couple of days that said, sounds great, but I can't wait 6 weeks. I simply don't have the ability to maintain my payroll and actually pay my employees for 4 or 6 weeks until that money starts to roll in. And so they're still looking at making those reductions because they simply don't have the ability to do it. Other businesses are saying, well, that's great, but the nature of my business means that I'm likely to see the impact of this starting in May, June, July, just the way that my revenues start to come in. And so the 30% reduction is not going to hit me until later. And so, there may not be eligibility, even though those consequences are likely to come for that employer as well. Keep in mind, you have leave provisions, both under the Employment Standards Code and potentially under collective agreements or employment contracts or your employment policies. Make sure that you're looking at those in the event that you have an individual who's coming to you and is looking for a leave provision. We talked in some detail with respect to the leave provisions that apply specifically with respect to COVID-19, but we still have the entitlement to up to 16 weeks of unpaid leave in a calendar year for illness or injury. You have the 5 days unpaid personal leave that can be taken under the Employment Standards Code. The sort of overwhelming view that I have from employers is that they're not having many employees coming to them and saying, gee, I'd like to take 5 days of unpaid leave. It's not a solution for an employer because obviously you still have to then deal with that employee at the other end of it. And there is a risk that if you grant some of these leave provisions under the code, that an employee might not be entitled or might be delayed in getting some entitlement to some of those government programs. And so in some cases, we have employees approaching employers saying, look, if you're looking to make a change, I'd like to be laid off because then I will be able to actually access some of these leave provisions. The last thing that I'd like to touch on is again, something that's been coming up more over the last couple of weeks, that is questions with respect to refusals to work. So under occupational health and safety, employees can refuse to perform dangerous work or where the working conditions are pose a danger to an employee's health and safety. The employer's got to report those dangerous conditions to the employer, and then of course the employer has a duty to take steps to remedy those conditions. And until those conditions are remedied, employees are not required to work. So we are looking now at whether or not employees might be saying, look, I'm refusing to work because I believe that COVID-19 is making my workplace unsafe, and therefore it would be a violation of the code for the employer to require the employee to perform those duties. So there's a number of factors that have to be considered. Of course, the nature of the duties, the typical duties that an employee is carrying out. What are the existing health and safety procedures? How severe is the risk of transmission given the individual's particular job duties? And so I've had employers phone and saying, look, we have one person who sits in an office all day and is now saying that they don't want to come to work because they're concerned about transmission. They have no contact with any members of the public. What do we do? That's very different from a situation where you have an employee whose main job duty is to interact with members of the public who may in the normal course require working with those people in relatively close quarters. So you want to be looking at what their job duties are, look at the recommendations from public health officials, and also make sure that you're checking back on Occupational Health and Safety's website. They've posted some new information about how to reduce the risk of transmission in the workplace, things that employers should be doing. So make sure you're doing all of those at a bare minimum, and look at those jobs which might have an increased risk of transmission to determine how different processes can be put in place to reduce that. So you want to make sure that if you have an individual who's interacting with the public, that you are putting some protective equipment within reach so that they'll be able to use those things. And vitally important from an occupational health and safety perspective is that you not only institute these rules, but you communicate them very clearly to your employees over and over again. So don't hesitate to use all staff emails to communicate your expectations with respect to hand washing, interactions, social distancing in the workplace. I've had some employers who have used text messages or group chats to make sure they're communicating with employees. Put up posters in the workplace reminding people of their obligations. And really importantly, for your lawyer down the road who you may be asking to help defend you in an occupational health and safety complaint, keep good records of all of those things that you're doing so that you'll be able to prove that you were taking reasonable steps to ensure the health and safety of your workers in the workplace. The final recommendation with respect to OH&S from my perspective is you of course have to make sure your workplaces are safe, put all of those procedures in place, but ask employees to tell you whether they have any additional concerns. So invite them to provide you with additional concerns or ideas that they may have to make the workplace safer. That's a really good way to ensure that prior to an employee picking up the phone and calling occupational health and safety, they actually think that they can raise an issue with their employer. And even if you ultimately don't agree, because for example, you think that their request is unreasonable in the circumstances, showing that you considered it and keeping a record of that fact will be important if you get an officer showing up at your door down the road.
Matt, I'm just going to interject if I can for a moment. Sorry, we're at 2 o'clock now. I just wanted to let everyone know that we're very close to the end. So if you have to leave us, please go ahead and do that and you will get the recording after. But for those of you who are able to stick around, we are close to the end. Thanks.
Thanks very much, Christine. And in fact, that was the last bit of information I had with respect to occupational health and safety matters. Anthony's covered the government programs in lots of detail, and so I don't intend to go over those again, but just keep in mind that when you're looking at what you can do in your workplace to deal with employment situations, to try to limit your exposure to expenditures that may not be justifiable in these circumstances, that you should be considering your options that we've talked about before, and also looking at how those interact with those government programs so that you can advise employees about the fact that, look, if they're laid off, here are some resources that they can access in the event that they are eligible to do that. So I'll turn it back over to you, Christine. Thanks very much for your attention, everyone.
Yes, I just want to echo that. Thanks so much for joining us today, and thank you, Matt and Anthony, from coming in from your respective homes. As I mentioned earlier, the link to the recording will be forthcoming, so you can watch this as many times as you like. And please feel free to share the link with whoever you think might get value out of it. Although we have a limit on the number of live participants we can have in these webinars, we're not limited for just the views of the recording. So please do feel free to share. If you have questions, I will put the contact information for both Matt and Anthony up there. Please do feel free to reach out to us. We also have an entire team of employment lawyers, so Matt and Anthony are not the only ones, but they're the ones here. If you have a question and you're not quite sure who you should be asking, please feel free to send an email to clientrelations@rmrf.com. It will come to me, and I can make sure that you're directed to the right person. This is the second webinar that we've done on employment matters. Our intent is to provide them, to continue to provide them so long as there is value and there are sufficient changes. As Anthony mentioned at the beginning of this, certainly there was a lot that happened in those first couple of weeks, and we've seen a bit of a slowdown. So we don't have anything planned currently, but to the extent that there are changes and we think that there is value for you, we will be having more of these webinars. So please feel free to check out our website. We'll be posting everything there. And you can also find us on LinkedIn, and we'll be posting a lot of updates. And with that, I think we're done. I hope that everyone is staying safe and healthy.